If you follow me at all, you know I always say how important it is to have an expert in the area of probate and estate planning and conservatorships rather than a generalist. And LA is so big with so many different multi-markets. I'm really excited today to introduce somebody who I've seen online, who I think is a great talent in that area and is based in the South Bay, Beti Bergman from the Palos Verdes, Torrance area. Beti, thank you so much for your time today.
Oh, you're very welcome. And thank you for having me.
One of the things that jumps off the page, I saw you in video and I loved your message and your knowledge of the market. I went to your website and I noticed that unlike a lot of attorneys, you really list three things: trust, estates, and conservatorships. Very narrow focus, which I think is great. How'd you end up with such a narrow focus in your practice?
Well, when I started out and hung out my shingle and decided that I am going to be a probate lawyer, because I used to be a civil litigator before, I really had the focus of doing probate and probate only. And I kind of subscribed to this Bruce Lee saying, who he said that you really should fear the man who has done one thing 10,000 times rather than a man who has done 10,000 things one time. So I really wanted to be a specialist and an expert in probate law. And that's all I did. And I immersed myself in this field. And so I only deal with probate, trust, conservatorships, so that I can be an expert at it, at that in those fields, and know it very well. And that's what I do. So that's what I focus on.
Now, I've been in this field myself, exclusively for about 5 years now. And I know that even by going to court every day and following the industry, even with the narrow field of probate, there's a pretty wide range of activities from probates and trusts, conservatorships and such. So within that, is there a particular focus, or is there a kind of a most common area that you spend your time in?
Yeah, and I would say those three things. You're right, because probate law is an umbrella that covers a lot of different things. And that could include estate planning. It could even include maybe Medi-Cal planning. It could, there's a lot of things. I do focus on probate, doing probate administration, which includes, administering assets that are going through probate, selling real property under probate, things like that. Same thing with trust administration, and conservatorships. They also there's administration involved as far as administering a conservatorship estate that has assets and having a conservator manage a person's life. But in all three of those fields, I also do a lot of litigation in those areas, in probate, trust, and conservatorships. So a lot of times these things explode into litigation, unfortunately, and I'm in the position of representing either the fiduciary in those kinds of cases or the beneficiaries in those cases, and we're litigating for some reason or another. So I think that would probably accurately describe the focuses that I have under the probate umbrella.
I've noticed that there are attorneys who do both administration of probate and trusts and litigation, and those who only do litigation or only don't do litigation. Your choice is to do both. Explain to me how you came to that decision and how you think that serves your business and how it serves your customers.
Well, I've always been a litigator. So I have, I think this is my 27th year of practicing law, and my entire career, I've been a litigator. Now, when I did start out my probate firm, I did think about not litigating anymore, and kind of, because at that time I had a family and I thought that litigation is going to be very consuming, and I was thinking of just doing administration and perhaps estate planning. But I think early on in my career, when I hung out my shingle, one of my cases blew up into a litigation. And I just thought, okay, I will go ahead and do it since I know how to litigate. And I think that particular case lasted 4 years, and more litigation cases came through during that time and continued to come through. One of my passions is to be in court. I like being present in court. I like arguing in court. I like trials. Has always been fun for me. So I think I just continue to do it.
Nice. So it was more the litigation background that brought you into it. And I, it's interesting because I've often felt that attorneys who don't do litigation may not get the feedback loop of what they should have avoided had they done things differently. I think if you're a litigator, you're picking apart the mistakes in a way that just doing the work every day you won't. So for me, and I know there's two theories, and I'm not saying the other ones are wrong, but I kind of buy into that. And I think it's important that a customer understand if they're going to use you to administer their estate or trust, do you litigate as well? And you may or may not litigate that case on their behalf, or you may, but I think it's important to at least know the person that you're dealing with. So in litigation, there's obviously two types. So those people, those cases that seem to me, they're going to work out their emotional issues in court one way or the other, and litigation is kind of like an expensive form of therapy. There's often times where maybe it's a mistake that was made or something that could have been done to avoid litigation that wasn't done properly. What are one or two things that you see that people do that or didn't do that leads to litigation that might be avoidable?
Oh yeah, I think that yeah, and you're right. Let me go back on a point that you made, that it is important. I know that some people usually do non-litigation, like there's estate planners that don't litigate, and then litigators that don't do estate planning. We do estate planning as well. And I think it is important because in the estate planning process, if you know how it could come apart at the end and get litigated over, then that's important to know as an estate planner or in an administration, so you don't make some mistakes during the administration process too. But also, if you're litigating, you know how these trusts or estate plans got written and why those terms are in there, and that's also important on the litigation side. So if you're doing one side, and I'm not necessarily saying people need to do both sides, but if you do, I think it is very, very helpful, and those are areas of knowledge that is very valuable to a client. So I'm sorry. So what was your question? I think that was another question.
Well, so what are one or two things that you see people do that leads to litigation or don't do that they could have avoided litigation, but they left out in their estate? Most commonly in estate planners, are one or two mistakes people make that opens them up to trouble that you see from time to time, or one or two things they didn't do that would have foreclosed that option?
Well, and some things that happen, and it's not necessarily wrong to do it, but sometimes people want to name, let's say if they have two kids and they want both of them to be co-trustees after they die. And that's very common and understandable because the parent doesn't want to favor one child over the other. But you do have to consider whether these children or the two co-trustees that people name will get along. Because if they don't, I have many cases where one co-trustee is suing the other because of their distrust, or, and some rightfully so. And they are not doing things together right. Some things, one of the co-trustees kind of unilaterally does something without telling the other co-trustee because they think they don't need to, though the trust probably requires them to. And so that is probably a common mistake that people may not consider or may not want to consider, like I said, because parents don't want to favor one child over the other, but they usually name two of their children to act together, and these children just can't get along and never have gotten along. And so that's a problem. And so so there's a lot of, there's litigation can ensue because of that. Another thing is to address whether co-trustees should be able to act independent of each other, or if they need to act unanimously. The default law is that they have to act unanimously unless the trust says they can act separately. And so you really want to consider that, because a lot of times these people cannot act together. I mean, it's kind of, practically speaking, it's probably not that realistic. Sometimes these co-trustees live apart, like they're in different states or something like that. And it's not practical for them to sign off on every single transaction like a check or something like that. So that's something that people need to think about. And then if they're not allowed to do that, and then the one co-trustee starts doing things unilaterally, and the other co-trustee is up in arms about that. So that's something to address too. Disputes.
One of the challenges I see in the probate marketplace is, parents pass away, leave a house to sibling, a child, multiple children, worth $500,000, $1 million. That child, whatever reason, never financially amounted to much. They have a job, they pay their bills, they never bought a house maybe, and now all of a sudden they're going to come into $500,000, $1 million. And the business side, like I'm a real estate agent and I deal with this all the time. A homeowner has been to the dance once before. They kind of know there's a lot of paperwork. They know they got to sign things, but oftentimes I find heirs will be overwhelmed with the administrative requirements of the process, and their expectation is that the attorney does that, but really the attorney is the legal reference. They're not the administrator or a fiduciary. So how do you kind of coach up customers, or do you encourage? I know that on large estates, commonly we get professional fiduciaries. It's not as common on smaller estates, but from where I sit, oftentimes it's the smaller states, the $500,000 one house property, where the heir needs a fiduciary and isn't able to get the job done. How do you kind of handle those situations where the heir needs help, but you don't want to sign on to do the work, obviously, as an attorney? How do you help them through that process?
Well, so in that scenario, are you saying that the heir is the trustee that's having to administer the distribution of the trust to themselves, essentially?
Or probate? I'd say more common probate, where there's more paperwork involved and more forms and signing things, and you get an offer, you counter offer, and there's a lot of paperwork with the escrow and the accounting forms. It just seems that for some people, and I'm not being judgmental, they've just never been through that much paperwork. They have a job, they do their job well, but they never bought a house before, and I like to see the amount of paperwork to do a house in a probate. I find it overwhelming, and I'm a professional. So, and I see attorneys often frustrate that customers can't do it, and at the same time, some people can't do it. And so one of the things I've been working on is trying to push people towards getting a fiduciary, try to find a lower cost solution that includes that, because I know the attorney doesn't want to do the fiduciary's job and not get compensated. That's reasonable enough. Do you see that problem from time to time? And if you do, how do you help resolve that?
Oh, sure. Because most people who get into the position of having to be the successor trustee to administer a trust, or an executor, personal representative, administrator in a probate, they're lay people. And so they don't know how to do these things. And it's very, very complicated. So the number one thing that these people must do, of course, is get advice of a professional, of a trust or probate attorney who knows how to do this and knows how to walk them through the process. It's very, very important for these people to make sure that they retain an attorney who knows how to do these things. Now, there's going to be a lot of attorneys out there that are really not specialists in this field, and they think, oh, sure, I'll help you with the probate. And they do not know how to do any of these forms, like you said, especially when there's a sale of real property. It has to go through a court confirmation process. And if it's not a specialist who knows this area of law and how to do these things, it is a nightmare. And you will get continuances and continuances of these court hearings because the paperwork is not done right. At the same token, you getting the realtor who sells that probate property or the trust property, you really need to retain a realtor who knows what they're doing, that knows how to do a trust sale, knows how to do a probate sale, knows the court confirmation process of how a probate real property needs to be sold. If you get people in these places, it could be any regular realtor, any regular attorney who does not know this process, it will be a nightmare. You will never get the process done. And you'll find yourself having hearing after hearing after hearing because the paperwork is not done right. That's the same thing with court accountings, because in a probate estate, you have to do a final accounting and a final distribution, file a petition to get that done. I've seen it time and time again where there is a practitioner that just doesn't know how to do this, and it's a nightmare.
Yeah.
You know, and they never get it done until they get someone in place who knows how to get this done.
And you can save money, you think,
Right.
but an extra 6 months of paying mortgages, taxes, and in LA today, maybe squatters break in your house or something happens to the property. There's just nothing good. I would say there's nothing good that happens from the day you file probate until it closes. Everything is bad. Everything is bad. Same with real estate. There's nothing good from the day you list a property until the customer gets the check. Everything is bad. You get paying interest, taxes, you have risks, it's work. There's nothing that's good about it. So I think you and I, and that's why I reached out to you, as I saw you, and I know that you are a specialist in this area. And the one thing I tell customers all the time is, if you're going to get an attorney in this, just make sure this is what they do, because
Right.
the law is just very broad, and you need somebody who really knows this stuff in particular. You know, Beti, I really enjoyed chatting with you. I'm sure I could talk all day long, but I'm sure we have people watching who have questions, who might be interested in talking to you about their probate case or estate planning needs they have, or conservatorship possibility, or litigation. I know your website is peninsula.law. Is that the best place to reach you?
That is correct. Yes. Please visit our website.
Fantastic. So Peninsula Law, I'll put it in the description as well below. Thank you so much for your time today. I really appreciate it.
Oh, my pleasure. Anytime.